So welcome to our webinar, Dependence to Independence, Crucial Documents for Your 18 Plus Child. Today we're basically going to go over everything parents need to know for when their kid turns 18, what kind of paperwork you might need, basically everything that you need to know about guardianship and the fact that they're now a legal adult. So Dubs, would you like to introduce yourself?
Yeah, thank you, Kara. I appreciate it. My name is Dubs Herschlip. I'm a Washington attorney, so all of my discussions today are going to be based on Washington law, but this doesn't constitute legal advice, as it's just general review of law in Washington as to people turning 18. Kara mentioned a guardianship. We're going to touch upon that briefly, but generally there isn't going to be too much discussion about guardianship because we're generally giving this advice as an alternative to guardianship, knowing that a guardianship is a full-fledged court case that could be costly and time-consuming. And so a lot of this discussion is going to be as an alternative to a guardianship. Yeah, and so I've been practicing for about 23 years in Washington, have substantial estate planning experience as well as probate litigation and other litigation. So I have a lot of experience in how to draft these documents and also how these documents are put into place in the real world on a practical basis. And I also have children who are getting ready to apply to college and go through all the paperwork. In Washington, we also have laws about child privacy for medical records that kicks in at 13. So there's a lot of those issues that I've been experienced with. And so I'm happy to share that also with people here on the webinar.
Thanks, Dubs. Could we begin by doing a quick overview of some of the legal documents that parents like yourself should have in place for their young adult children, either before they turn 18 or when they turn 18?
Yeah, so the documents really could vary from person to person, and the concept here is to just have a plan in place just in case. Largely in the event of financial emergency or medical emergency, these documents are going to be super helpful in helping your child that until now has been completely dependent, and from the moment that they turn 18 or the moment that they move out, they're approaching independence. But as we all know, children are still going to rely upon their parents for at least some time into the future, and these documents are going to help facilitate the parents' access and communications, etc. And some of those documents are a medical power of attorney, a durable power of attorney for finances, a FERPA release, which is the Family Education Rights and Privacy Act release, and a HIPAA release form. I'm going to back up and kind of explain what each one of those are because it's sometimes a little bit confusing. But a medical power of attorney is a document that allows a child to name their parent as their agent or as their decision maker to make healthcare decisions if they're unable to do it themselves. So this helps the parent with the ability to consent to medical care in case your child's in emergency and needs emergency surgery and they're not conscious. This would allow the parent to step in and consent to the surgery, as well as to communicate between the medical provider and the health insurer to get pre-authorization through the medical insurance plan if that's required, and also to, really an unhappy topic, to withhold or withdraw life-sustaining procedures. The next document, the durable power of attorney for finances, allows the child to designate their parent or their agent or caregiver, or ward is another phrase or word that people use to describe this, to help them manage financial transactions, such as bank accounts and real estate purchases or investments or college expenses, living expenses, credit cards, etc. Is what the durable power of attorney for finances would be for. And then the FERPA is what grants the parent access to the child's personally identifiable information. So that's a catchphrase, or that's a legal term of art. When that is regulated. There's privacy acts all over the country, as well as federally, that protect personally identifiable information from being exchanged. And here, the FERPA release allows the college to release information about people over 18, students over 18, including educational records like grades, etc., to the parent, usually the person paying, or in this situation, the parent's usually paying for the education. So they want to know how the student is doing or their child is doing in school, and they wouldn't otherwise get that information without a FERPA release form signed and on file with the educational institution. And then the last one is a HIPAA release form. And that HIPAA release is we have a form, but it's also important to recognize that each medical institution usually has their own internally approved HIPAA release form. So even though we may be able to provide you with one, there may be hiccups in that each institution usually has their own HIPAA release form that they require instead of whatever one you might be providing. They also tend to expire within 90 days. And this form should give you access to all medical records. And I say should because I still see problems with some electronic medical record systems like MyChart and parents getting access to see labs or to schedule appointments. It still is quite problematic. So there may be additional measures that need to be taken in order for those documents, the HIPAA release form, to be effective in accessing your child's lab results or appointments or whatever. And in part because Washington law protects your teen's medical privacy so that it can guarantee the sensitive information of the child and guarantee that it maintains confidentiality between the teen and their doctor. And Washington doctors are very in tune with this and often are the source of the pushback. So this is going to be just a little dabble into children under 18 because in Washington, when kids turn 13, Washington state law allows them to make medical decisions without parental consent as to birth control, mental health treatment, and testing for sexually transmitted diseases or infections, STIs. And so with those in place and doctors understanding that their outcomes are going to be better if their teen patients have the confidence that their medical information is going to be maintained as private, they often push back and don't communicate with the parents. So in addition to the HIPAA release form, it's often important to speak to your child's doctor beforehand so that you can communicate with them, get them on board with your access, get the child's consent with the doctor, usually verbal, because the doctor just wants to confirm outside the parent's presence that the child's okay with this consent. So it's important to also have the doctor involved in the conversation. And then within the online medical system, the form itself isn't going to be enough. You're going to have to look to see how you can add yourself as a proxy. That's usually how they list it, to access your kids' records that allow you to do things like message the medical care team or view, schedule, cancel appointments, refill medications, get access to immunization records, view preventative care reminders like regular physicals and that sort of thing, and also to view and update insurance information. The legal risks back to 18. So the legal risks that I'm jumping past your
I
conversation,
was
Kara.
just about
Sorry.
to ask about that, Dubs.
Sorry about that.
What are the legal risks that your child might face without you having that proper documentation in place after they turn 18?
Yeah, thank you. And so if you don't have these documents and you haven't taken these steps before your child turns 18 and they go away to college, then the major risk or the common risk is that the child may have to be solely responsible for financial or medical decisions and transactions. And that could be bad, and not only bad in the form of, maybe there's going to be unsupervised financial decisions made by a child that are going to be consequences for the parent later, but there could also be, as mentioned, an emergency medical situation that if the child doesn't have the capacity to consent to medical decisions, then an emergency guardianship might have to be brought in order to authorize surgical intervention in the case of incapacitated children.
So, what are the potential consequences of not having those right documents in place once they turn 18? Um, does that affect things like the power of attorney and the guardianship?
So yeah, all of these documents really can't be consented to by the child until they turn 18. So really, this is a question that we want to have with people before their children turn 18 and leave, because we want to make sure that they're in place at the time that they're 18. And there are often some onerous execution requirements, like you need witnesses or notaries. And sometimes it's just a little bit too complicated for children to get together, and so we want to make sure that we're having this conversation prior to turning 18 so that we can get it done as soon as possible after they turn 18, and have them in place for when they go away to school. Because once they're away to school, that's when the separation starts to happen, and the child's independence may take a turn, for the worse beyond what the parent would otherwise allow.
Yeah, I could imagine it would also be difficult to get any witnesses together or even to have them at home at the same time as you. Like, I think the first chance for that's what, Thanksgiving break, fall break. You're going to be
Yeah,
away for a
right,
while.
right, right.
Yeah. Makes sense. So I guess that's a bit of a fraught period from when they turn 18 until when these documents are actually able to be signed. And we want that time frame to be as small as possible so nothing happens in between.
Exactly. That's right.
Okay. So what are some of the common scenarios where having these documents would be really helpful? I know you mentioned a few already.
Yeah, we can dive into these. These are probably going to make more sense to the people in attendance than the legal jargon. But so one of the common issues is the medical emergency and lack of health insurance information. Sometimes it even changes when the child goes to school. Many colleges offer health insurance information. I mean, health insurance to students. But it's also important to remember that under the Affordable Care Act, children can still rely on their parents' health insurance until they're 26, but getting that health insurance information to the child may be the issue, and then to the medical provider. And once there's a medical emergency, it's a little bit late, kind of too late. For the child who's possibly in need of immediate attention. So, for example, if you have a child that turns 18 and they were living with their parents and they have a car accident and serious injuries and they're rushed to the hospital, because that person's now an adult, the hospital will require the adult child, to consent to treatment and to provide his health insurance information, his or her health insurance information. And if the child isn't used to that, they're going to be clueless, and they may even be incapacitated and not have that information on them, as well as the fact that the primary insured might actually be the parent under the policy, and so then their authorization or their information may also be required in order to process the insurance application. So where the child doesn't have the parent's health insurance details and doesn't have a medical power of attorney or the HIPAA release form signed prior to the accident, then the hospital can't even legally discuss the medical care or that he's a patient, or how to process what the insurance is, how to process any of that without his explicit consent, or the child's, sorry, explicit consent to the parents' involvement, whether it's they're getting access to the medical information or the insurance, or communicating even with the doctor. And so where the child is unconscious and unable to provide the necessary permissions and insurance information, there's going to be an unfortunate delay in care that can have, medical consequences that would be unfortunate and avoidable. Another example beyond the crisis of medical emergencies, we also have the bank account emergencies or bank account access information. So where you have a child, or where we have children, as I have children, and they turn 18 and they have perhaps a joint bank account. That seems to be what people like to do in order to manage finances. And then the child goes on a trip, loses their debit card and identification documents, they would then be unable to access the funds. So You'd think that it's good enough to be a joint account holder, but the bank can actually require the child's direct consent to issue a new card or to make any significant changes to the account because that person's an adult. And so without proper documentation, which would be the durable financial power of attorney, the parents may not be able to immediately access or help the daughter child access the money. And in that situation, with the parent as a joint account holder, negative balances may also end up going against the parent's credit history because that joint account would be listed under their name as well. So negative consequences to both the child and the parent could be avoided by having durable financial power of attorney executed and a copy delivered to the bank so that they know that the parent has authority over the account as a holder of the power of attorney for the child. A third scenario, we're going to do 5 total. A third scenario is the college financial aid complications. Child turns 18, applies for college financial aid, and she needs to submit financial documents, including her parents' tax returns and proof of income. Well, the parents might have all that information, but due to the child's status as an adult, they may not be able to submit the information without her authorization, the child's authorization, or even to communicate with the educational institution or the financial aid provider. And again, the child not having the documentation with her at school will delay the financial aid and possibly risk the child's enrollment status in college. So again, the FERPA release form and power of attorney would help the parents communicate with the school and with the financial aid provider and avoid any unnecessary delays or enrollment disqualifications. Fourth scenario is the consent for surgery. Similar to the car accident one, where the person, the child is, rushed to the hospital. And even if the parents are with the child, if the child is in severe pain and not able to understand what's going on, or maybe the arm's broken and unable to sign consent forms, again, the parents can't sign on the child's behalf because there's no medical power of attorney, and that would delay the surgery. So again, having a medical power of attorney signed by the child designating the parent as the medical decision maker in the time of incapacity would be the ideal situation. There is a little caveat here, which is that most medical institutions have on file something called a POLST form in Washington, a physician's orders on life-sustaining treatment that the hospital may provide and have filled out at that time. But one of the problems is that the witnesses on that form can't be the medical providers. So then the child's going to need witnesses at this time of crisis, and it might be tough to execute that form at that time. So again, it's important to get these things done in advance. And then the fifth scenario I kind of mentioned was the unable or inability to access academic records. So where we have a child, turning 18, graduating from high school, and needs to get academic records to her college, uh, that that child is going to need a release and possibly a power of attorney for the parents to gather her school paperwork and forward it to the college in order to transfer records. But if the child is out of town at college, then it might be difficult for the child to run these errands and gather the necessary forms, and then again cause delay in the college admissions. So we want to avoid those by having these forms in place. And if we don't have the forms in place, then that leads us to needing a guardianship, which is the court alternative or the litigation alternative to having these documents planned and executed. And so we really want to kind of avoid that option or that opportunity to spend a bunch of money on litigation fees for guardianships if possible. I
So
can give
Dubs,
some
what are
examples.
some cases where a child turning 18 would need guardianship paperwork done?
Yeah, so scenarios where guardianship is necessary and the paperwork probably, or not probably, and the paperwork can't happen, right? So once some of these events have happened, then there's no going back and executing a financial power of attorney or healthcare directive or any of these documents. So then a guardianship is necessary in 5 scenarios that I can think of. Those are severe developmental disabilities, mental health crisis, traumatic brain injury, severe autism, or accident-induced coma. I'm going to go back through those and just kind of explain how the guardianship plays a role in that. So if we have a child who has severe developmental disabilities and they turn 18, and despite the cognitive impairments, there's no guardianship in place, that person, the child, if they need urgent medical treatment, would still need consent for the procedure. And because the child can't do it can't give the consent due to their severe developmental disabilities, then the legal guardianship needs to be put in place over that adult, so that whoever the guardian is, probably the parents, will be able to make medical decisions for them. And because a guardianship is a court case, it can take time, days, perhaps weeks, in order to get the proper documentation in place, and that would delay critical care. So that would be something that we'd want to avoid. Another example is mental health care, or I mean, sorry, a mental health crisis. We're seeing that happen at a very steep incidence of occurrence now with teenagers, and the social media crisis, depression, suicidality, etc. So in those situations where a child has a history of severe mental health issues and then turns 18, if they experience a psychiatric crisis after they're 18 that requires hospitalization, then their inability to comprehend or consent treatment during that time, during the psychoses or whatever the crisis event is, the parents would like to intervene but can't without a legal guardianship, because again, the child's 18 and the psychiatric facility may not allow the parents to make decisions or to access the child's medical records, hindering the child's treatment and even the parents' notification of the treatment. I'd like to put a little asterisk in there that, as the parents probably the listed next of kin, they may get notice that the child is in the hospital or is in some sort of psychiatric care facility. That's about as far as it would go, and the parent may not otherwise be involved or informed or be able to make decisions without a guardianship in place. The third example, traumatic brain injury, is really, again, child turns 18, suffers a traumatic brain injury in an accident, maybe, sports accident, football, soccer, and is unconscious and then requires emergency surgery. Again, where the parents, even if they're present, will not be able to consent for an adult unless they have a guardianship in place. And the hospital might require a court order to allow them to conduct a surgery on the child, causing significant delays. And again, we don't want to wait around for a guardianship to be filed and a hearing to be held and then the orders to be issued, because that can cause significant delays. And then the necessary treatment would be delayed as well. Another example, the fourth example, is severe autism. If there's a child with severe autism who turns 18, that person is going to continue to rely on their parents for daily care and decision making. And so if they are, in need of hospitalization, for example, for an infection, the hospital will require the child's consent for treatment, but because the child may not be able to provide it due to lack of capacity, the parents would be the ones that would need to consent, but because it's an adult and they don't have a power of attorney or healthcare power of attorney in place, they would lack the authority to give the hospital that consent. And so then the parents would again have to file for guardianship in order to authorize the necessary medical procedures, and the guardianship could cause significant delays. Pretty much the same situation with the accident-induced coma. Again, without the legal guardianship or the power of attorney for healthcare decisions, then or even for financial power of attorney, the parents may not be able to provide the consent or the finances in order to pay the medical bills and process the insurance necessary for the medical procedure.
That seems like it would cause some issues with their bank accounts or anything, like if they're not paying bills.
Yes.
Um, So, Dubs, how long do these documents last? Is there a point where the parents no longer have these rights, even if they did the documents?
Yes, generally, delegation of decisions does not last longer than 24 months in the case of FERPA, and in the HIPAA release form, it usually only lasts 90 days. Generally, the power of attorney and healthcare decisions can last until death or revocation. So, this is kind of a set it and forget it situation. If the child gets these documents properly executed and in place at the time that they turn 18, then they can just be maintained on file until the child, revokes them or passes away. Um, and so then with the guardianship, because we've talked about it, although that's really not the focus here, but if there is a guardianship, those generally need to be renewed annually, or if and when the kid gets married, that might cut off the guardianship as well. So it really depends on the document and how long they last.
So, as a young adult myself, I'm curious why a young adult would agree to give their parents the power over them. Why would a young adult want to sign these documents? And this would be useful for the parents in the chat if they want to convince their young adults to do so.
Yeah, this can be a tough conversation. Um, the child may not want to sign these documents. But if they're used to mommy and daddy doing things for them, then they're going to want to sign these documents if they want to continue to rely on mommy and daddy to do these things. Otherwise, they just won't be able to. And then the child's road to independence is going to be littered with consequences, financial and medical. So really, the the approach or the discussion is that these are precautions in case the child needs it to provide a safety net. And, there really should be uh, a history of trust or a pattern of trust between the parent and child, that these documents will just be another element of that trusting and loving relationship where the parent cares for the child, and shouldn't be something abnormal or upsetting to the child because this is the person that they trust. And yes, they're giving a special power, they're delegating decision making authority in certain circumstances to the parent, but that parent has provided for the child's every need up until now, and should only do so in the event that the child does need the parents involved. So these documents really are to help this tough transition that parents have from doing everything for the child to the child doing everything themselves. And these documents provide a middle ground. So, yes, the kid's going away to school, and yes, they should feel all independent. But if the child's a little bit lazy on paying their bills, this will be great because mom and dad can swoop in and help out with checking the bank account, making sure it doesn't fall below zero balance, putting in spending money for food and groceries, that kind of thing. Um, and so that's a little bit of the appeal for the children. I'm not sure if I have attorneys here, but I do want to mention that attorneys here on the webinar should be aware of the potential conflict of interest in this situation, because the child may have a different interest or have different interests than the parents, and you drafting the documents for the child makes the child your client. So if you're the parent's attorney and the child's attorney, you're going to want to do a disclosure of the potential conflicts of interest and follow up with a written consent for you to stand in that fold between parents and child.
So I guess that's a bit of a concern for you getting with your kids getting to that age where they might need these documents.
Yes, it's definitely something that I keep in mind. I don't really anticipate any difficulties just because of the trusting relationship, but it's also, it's scary. It's to hear, to go from having no legal issues for 18 years to all of a sudden having to listen to, you know, legalese and fancy, powerful attorneys telling you what to do. It can be really intimidating. So it's a nice, long conversation to have with the child of, look, here's what's going to happen. It's totally normal. Let me know if you have any concerns. We're going to deal with them, as opposed to just kind of springing it on them and going, hey, look, sign these. Mommy, daddy can do whatever they want. Uh, which isn't necessarily true. Usually they are only in effect for financial power of attorney, for example. There are two kinds. There's one that's immediately effective or one that's effective upon disability. So if the child's concerned, we can take that power of attorney and make it only a springing power of attorney, meaning it only takes effect upon disability. That's probably not what most children want, in my understanding, for their finances. They're going to want, financial assistance from their parents no matter what. So then that would be an immediately effective financial power of attorney so that the parent can access the bank accounts no matter what. But for the medical, again, the child could say in the healthcare directive that I only want my parent making medical decisions for me in the event of my incapacity. And so it's not always effective, and the parent doesn't always get to make decisions unless the child can't. So there's a nice little safeguard that can also be offered for a concerned child.
So I actually signed all these documents when I went to college several years ago now. Um, and I did remember specifically thinking, like, how am I suddenly going from not having the right to consent to anything, not being allowed to do anything myself, and then suddenly it's you must do everything yourself. Your parents can't even help. So those kind of documents really, really did help the transition for me at least.
I'm glad to
Um,
hear that. Yeah,
Thanks.
and in Washington, it's a little bit longer of a conversation because the process, at least for medical decisions, starts at 13. And so parents on this webinar are probably already aware of the communication difficulties that they have with medical providers in Washington because the privacy rights kick in at 13. And so they're probably already experiencing some of these challenges, at least as to medical.
All right, so we can open up the floor for questions now. If you'd like to type them in the chat or ask them out loud. I actually had one while we were going through this. Um, and I know quite a few other parents have this question, so I might cover what somebody's thinking in their head. If a parent is paying for their student's college, do they have the rights to see their grades?
No, that's the reason for the FERPA. Um, the the this college is bound by a federal law to not disclose private information, which it's defined as personally identifiable information, which is name, address, sex, date of birth, social security number, and it's not a short list. It can go into personal details like what's your political affiliation and sexual preference, and nothing can get disclosed. So even though you're paying the bill and you may get to see the balance, and through that information you may actually have some evidence that your child is in school, they won't provide any other information because of the federal law protecting um, the PII, or the personally identifiable information of the child. And those laws have serious consequences for the schools, so they generally tend to enforce them. And so it's really important to get these documents in place.
Great. So we do have some questions in chat. The first one about was asking Debs if you do estate planning in Virginia. We
Oh,
actually just had two webinars with our Virginia estate planning attorneys where they discussed the same topic. So our firm does a lot of these student documents, these new 18 plus documents for young adults in pretty much all the states where we have estate planning attorneys. So we do that in Virginia as well. And then we have another question down here. If there's a medical power of attorney, do we still need legal guardianship forms?
yeah, that's an interesting question. So the medical power of attorney should be in place for acute events of crisis, that one decision is necessary or a couple decisions are necessary. And in those situations, the medical power of attorney is all you need, and that's why I'm recommending it. Is that the medical power of attorney, or what I call the medical healthcare directive, the advanced healthcare directive. Some people also call it a living will, although I find that very confusing. Um, those are necessary to avoid guardianship. However, in some situations, if there's an extended period of disability, like say the medically or the accident-induced coma or permanent developmental disabilities, on those situations where there's a long-term influence or decision-making period, then it might be a best strategy to put a guardianship in place. But no, generally these forms are as an alternative to or to prevent the need for guardianship.
Great. Do we have any other questions from audience members? I don't see anyone typing.
Well, while we're waiting, I do want to put a call out to our estate planning attorneys at DBL that just gave a webinar very similar to this and are licensed in the DC, Virginia area, to Dominique Braggs and George Riley, both excellent attorneys. And I think you can Google their presentation as well, and their contact information should be available on the DBL website.
We have one more question asking how much does it cost to get these forms done?
Yeah, so this really isn't meant as a sales pitch, so I'm not supposed to give out pricing on information because it can vary from person to person. We do have peace of mind planning prices set in place so that you can just hire us and we'll do everything that you need. There are also other places that offer individual forms for sale. I don't think DBL does that because we like to make sure that when we talk to our clients and listen to their needs, that we take care of all of those needs without regard to price, that we just get a hold of every single document that'll serve the client's needs and provide them to give the clients a peace of mind that everything's been taken care of.
Dubs, I do think that we have a bundle price available for at least our Virginia attorneys. However,
Oh, go
I'll
ahead and
send
give
out
that if you haven't.
Yeah, I'll send out information about that in the email after the webinar. Sorry, this wasn't meant to be a sales pitch for you guys. We just wanted to inform you about how you could help your children. Yeah.
Thanks, Kara. Yeah, that'd be really helpful.
All right, so I'm not seeing any more questions. So I think we could end it here if you'd like. Thank you everyone for coming. I hope that this was informative. Oh, maybe one more question. Thank you. They said it
Thank
was
you very
very
much.
informative. Thank you for coming. This will be up on YouTube. I will also send a link. So I'll send a direct link to you guys because you came. So you don't need to give us your contact information again to see it on our website. I'll also send you Dubs' contact information if you'd like to reach out afterwards with any more questions. So thank you so much for coming.
Thank you, Kara. Appreciate you.